they pulled up on me and told me to stop. And I asked if I was being detained. They told me to stop, so I didn't stop. I ran away from them. Huh?
You ran away from them. Yeah. You knew they wanted to talk to you?
Yes.
Did you know what they wanted to talk to you about?
No.
Somebody want to do some further inquiry? I'm not.
In the first case, the police had already had to go out 4 times for Mr. Scott at Village Grove to get him to leave, to get him to stop causing problems there.
I wouldn't mind going there because they the only ones can actually accept me because I have seizures and mental problems. That's the only thing I would like to do. I mean, if that's possible, I wouldn't mind going there.
Things is going to happen. He's going to just keep coming back on these charges every time. I don't know how many resisting obstructions he's had, but these are 2 more that are here.
Today's proceedings focus on a couple of defendants who had trouble with the law and are both facing obstruction of justice charges as a result. The first case involves a young woman who was walking down the road and had been asked to stop by the police, but for some reason she thought it was a good idea to disobey the lawful orders of the officers and decided to just keep on walking. There has to be an explanation. Will Judge Simpson be able to get to the bottom of this mystery? Stay tuned to find out. And for our second defendant today, we have a man who has been in Judge Simpson's court numerous times, and it's usually because of some sort of negative interaction with the police. He has a countless amount of obstruction of justice type charges and definitely suffers from some mental conditions. But the question arises, does this defendant pose a risk to public safety if granted release? Judge Simpson faces the weighty task of assessing the defendant's mental state and determining the appropriate course of action.
You got her. All right. I have a plea form. Is that what we're doing?
That is what we're doing today. Rights form also signed and filed.
The plea form indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing a police officer to 1-year offense. Upon a successful plea to that charge, the felony charge would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
Yes, Your Honor.
Correct. Scope, could you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the whole truth and nothing but the truth, so help you God?
Yes. Yes.
Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Do you understand that by pleading guilty, you'll not have a trial of any kind?
Yes. Yeah.
And also because you believe that you're guilty of this offense?
Yeah.
July 1st, 2023, at the location of 501 East Michigan Avenue, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with 2 police officers?
Yes.
What happened?
They told me to stop and I didn't.
To stop what?
Come to them. Basically, they wanted to talk to me and I didn't want to talk to them, so I just kept going on.
You were just standing there?
No, I was walking and they pulled up on me and told me to stop. And I asked if I was being detained. They told me to stop, so I didn't stop. I ran away from them.
You ran away from them?
Yeah.
You knew to talk to you?
Huh?
Yeah. You knew they wanted to talk to you?
Yes.
Did you know what they wanted to talk to you about?
No.
Somebody want to do some further inquiry? I'm not.
Scope, you were in a vehicle that day, on that date and time?
Yeah.
And you have the understanding that the cops, or the police officer pulled up into that vehicle?
Yeah, but I didn't run at that time.
Okay. So you were in a vehicle that the police stopped?
Yeah.
And then at some point you got out of that vehicle and started walking and they told you to stop
Yeah.
and you ran.
Yeah.
Okay, now that makes sense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
I'm satisfied, Your Honor. Proper.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be May 15, 2024, 9 a.m. Judge Bar, bond continued.
Thank you.
Courthouse case versus Raj Ante Scott.
Assistant Public Defender, Tanazi Kyriakamuli, Your Honor, on behalf of Mr. Barrage Scott. State your name for the record.
Raj Scott, yeah. Okay, what are we doing?
Your Honor, I've had an opportunity to talk to the prosecution. If there are no offers available to Mr. Scott, we would be asking to set this matter for preliminary examination, Judge.
People, discovery is complete.
Yes, I do have all the discovery that I think I need.
People would have their witnesses available tonight. Well, I do, but.
And Your Honor, Mr. Scott would like for me to address bonds.
Of course he would. Go ahead.
Your Honor, we are asking that the court consider releasing Mr. Scott, at least on a GPS tether. I don't have to say too much because I know the court is very familiar with Mr. Scott. He did indicate to me at the last hearing that the court stated that they would make a consideration of a release at the next hearing. Mr. Scott, these are nonviolent offenses, Your Honor. I understand that, well, that does weigh just a little bit at least. We're asking, Mr. Scott has come to some significant realizations about his mental health as well as his physical health. He indicates that he has been working with CMH. He is looking to get into some type of therapy, some type of outpatient treatment programming. He also indicates that he's requesting that the court place him on a tether. He has an elderly grandmother and grandfather that he assists significantly. He's currently on Social Security right now, and he just was able to receive that, according to him, after a long, extensive time in custody where he did not have that. He is afraid that if he remains in custody much longer, he's going to lose that and have to start all over again. He does have a place to stay. He is okay with being tethered to his grandmother's house. He indicates that she is willing to take him back and he can stay at her home, and he could at least restart his treatment with CMH. There are certain injections that he receives. He said there is a form of that injection available to him at the jail. However, it's not the specifically prescribed one. So, Judge, we're just asking that Mr. Scott be allowed to at least be released on a tether pending this preliminary exam.
Thank you, Your Honor. We had a lengthy bond hearing the last time we were here. So just first, these are violent offenses. Certainly the victims are police officers. The violent acts the defendant committed against these police officers. In the first case, the police had already had to go out 4 times for Mr. Scott at Village Grove to get him to leave, to get him to stop causing problems there. And it was only on the now 5th time of them being there that they had to take him into custody. I did a lengthy argument last time. He was explicitly ordered not to go to Village Grove. He goes right back to Village Grove. He engages in the exact same, and it is violent behavior against these police officers. Frankly, I really don't know where he would go, and certainly a GPS tether is something on his ankle, but I don't actually know how you keep him from going back to Village Grove. He's already been ordered not to go there. A tether is not going to physically prevent him from going there. Thank you.
Here's the cold hard reality with Mr. Scott. They could put him on a tether, done it before. He'll behave for a minute. And then he's out again. And it doesn't surprise me that in this case, officers went out there a number of times. At some point, that whole type of communication breaks down and Mr. Scott begins to attack them. The cold-hearted reality of this is that Mr. Scott needs inpatient treatment. That's really what he needs. And one of two things is going to happen. He's going to just keep coming back on these charges every time. I don't know how many resisting and obstructions he's had, but these are two more that are here. But he'll just keep coming back. And he's either going to come back here in the form of these cases, or quite frankly, given the way that he's conducting his life, it's going to be an obituary. And that's what I'm aware of. So I would release him to inpatient, but I'm not releasing him otherwise. Maybe Judge Barr after the exam will feel differently, but I'm not doing that. His bond will continue. Raj, I'll let you talk to me, but I'm not changing my mind.
I just want to know something, just a quick question. So you would release me to inpatient treatment, right? Just asking.
Yeah, inpatient. You, Raj, listen.
I just wanted to know. I wasn't trying to be disrespectful.
No, you know, quite frankly, Mr. Scott, there's only one time that you appeared before me that you've at all ever been disrespectful. Like that is not, and you were just frustrated when you did that. Yeah. I'm not. So I don't think that of you when you're talking.
Yes,
all right.
Yes, sir.
But I'm not letting you out till you can get yourself some help. Because Barrage, and I'm just going to be blunt with you. I don't want to see you in a coffin.
I never heard nobody say that before, but I really appreciate you saying that.
And you know what I mean.
Yeah.
You know what's going on with you. And one of these times, you know, my great fear right now is I let you out, that you don't even come back to me with another charge. You got to get help, Raj.
I understand that. I'm willing to take that help that you're giving me today. I just want to know how long I would have to do the assessment and stuff like that, because I don't know.
Council knows I'll sign whatever order. If it's going to get you into inpatient, I'll sign whatever order I got to sign, Barrage.
Well, what can I ask you a question? Because I really I just want to let you know some of them don't accept me because I have seizures. The only one that accepts me is Oakdale Recovery Center. I wouldn't mind going there because they the only ones can actually accept me because I have seizures and mental problems. That's the only thing I would like to do. I mean, if that's possible, I wouldn't mind going there. And I
Barrage,
do the right thing.
Barrage.
Yes, sir.
I don't know what you just said, whether that's true or not.
No,
But okay, I'll take you at your word. But what I'm saying is, it has to be an inpatient treatment. That's the only place we're going with.
Oh no, I understand.
Okay.
Inpatient treatment. It's inpatient treatment. Would accept me because I have seizures.
I know. I hear you.
Okay.
I'm hearing you.
I just didn't want you to be like, you know, it don't make no sense to what I was saying. That's all, sir.
No, every time you come here, you make sense.
Yes, sir.
I may not want to hear it, but you're making sense.
It's all right.
All right, Barrage. You take care.
So when do I come back to court?
On the 9th, well, you'll be before Judge Barr.
Is it here? Am I in person or
You're in person.
is it here?
Oh yeah, it'll be in this building.
Okay, I just wanted to know. Thank
Yeah.
you.
All right. Don't worry about it. We got somebody to get you there,
All right,
so you don't have to figure out where you're going.
All right.
All right. It's facility. Where you can try to run whatever scam you can run.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.